prepared heads of argument.
And your colleagues?
From
Oh, yeah, fine, okay.
yeah, yes,
Yes,
Yeah.
already handed me.
yes. I've just given to my colleagues.
Oh, okay, fine, okay.
Yes. My Lord, the heading for our address is admissibility of a recording made by Magistrate Cronje during the taking down of the statement of accused number 2, pursuant to Section 217 of Act 51 of 1977 process. We deal with the matter under the following headings. Section A is the introduction. Then on page 3 of the heads, under the heading B, we deal with the relevance and admissibility of the recording. Then on page 4, under the letter C, we deal with the characterization of the recording. And on page 5, under D, we deal with the issues that must be proven by the state for the admissibility of the recording. My Lord, then just to come back to page 2, paragraph 1, we mentioned that the trial in this matter has progressed to a stage where a consolidated trial within a trial is being held to determine the admissibility of statements made by accused number 1 and 2, pursuant to Section 217 of Act 51 of 1977. The state has already led the evidence of 2 witnesses regarding a statement made by accused number 1 in terms of Section 217 of Act 51 of 1977. At issue currently is the admissibility of a statement made by accused number 2 pursuant to Section 217 of Act 51 of 1977. And in this regard, my Lord, the state has called Mrs. V. Cronje, a relief magistrate attached to Boksburg Magistrates Court and performing duties at the branch court in Vosloorus, who took down a statement of accused number 2 on the 24th of June 2020. In paragraph 2, we mentioned that the defense has challenged the admissibility of this statement by accused number 2 on the basis that it was made under duress and not made freely and voluntarily, and furthermore, that he did not sign the statement. In paragraph 3, we mentioned that Magistrate Cronje testified that she recorded the making of the statement before her by accused number 2, who was assisted by an attorney, Mr. Dominic Ntokozo Mjiako, on her work-issued laptop just before she started with the completion of the pro forma, which serves as Exhibit JJ before this court, for the taking down of a confession. She testified that she did not inform the accused and his legal representative that she was recording the statement. She recorded it mainly out of keeping with practice when doing work in her office, out of personal choice and for her own safety, and not for official purposes. Paragraph 4, the state seeks to tender this recording as evidence. We mentioned, my lord, that all the parties as well as the accused were afforded the opportunity to listen to the recording over a period of 2 days. Now, the state seeks to introduce the evidence to supplement the pro forma completed by Magistrate Cronje, insofar as certain details might not appear on the pro forma, but contained in the recording, on the basis that the recording is merely an electronic version of the pro forma, Exhibit JJ. Paragraph 5, we mentioned that the defense is objecting to the introduction of the recording into evidence. We mentioned, my lord, and this is important, that the defense case has not yet been put to Magistrate Cronje. The basis of the objection was mentioned by counsel for accused 1 and 2, Advocate Mngomezulu, as being the need to adhere to the best evidence rule, and that the content of the recording must be referred to an expert. So we submit, my lord, that the originality and authenticity of the recording is being challenged, hence its admissibility, with the consequence that the state is precluded from playing the recording prior to its to the determination of its admissibility. Then in paragraph 6, we mentioned, my lord, that yesterday we referred to section 5 of the regulation of interception of communication and provision of communication related information. It's Act 70 of 2002. And section 4, we've already quoted it, but we just want to rehash it. It says, and we quote, any person other than law enforcement officer may intercept any communication if he is a party to the communication, unless such communication is intercepted by such person for the purpose of committing an offense. The court raised the issue during the debate yesterday as to whether Section 2 of that Act is not in conflict with Section 4. And we briefly refer to Section 2 of the same Act, which provides that, and we quote, subject to this Act, no person may intentionally intercept or attempt to intercept or authorize or procure any person to intercept or attempt to intercept at any place in the Republic any communication in the course of its occurrence or transmission. And we close quotation. We submit, my lord, that the intention of the legislature was to regulate the interception of certain communication. That is very clear from the from the heading of the Act, mainly for purposes of committing a crime, as mentioned in Section 4. And we make the point, my lord, that hence a magistrate permission is required to access a person's cell phone data, and that can only be done in the course of a criminal investigation. We therefore submit, my lord, that Section 2 does not apply in this matter. If one looks at the definition section of the Act, intercept means the oral or other acquisition of contents of any communication through the use of any means, includes an interception device, so as to make some or all of the contents of communication available to a person other than the sender or recipient or intended recipient of that communication, and includes A, the monitoring of any such communication by means of a monitoring device, B, viewing, examination, or inspection of the contents of any indirect communication, and C, diversion of any indirect communication from its intended destination to other destination. My Lord, we've mentioned that Ms. Cronje has indicated that the recording in question was not meant for official use, but more out of practice when performing administrative functions to safeguard herself. We therefore, my Lord, submit that the recording doesn't fall within the purview of Section 2. Then, my Lord, coming back to our heads under B, we deal with the relevance and admissibility of the recording. We refer to the writers D.J. Zeffert and A.P. Pazis in their book, The South African Law of Evidence, 2nd edition, 2009, at page 237. They mention that, and we quote, "Relevance is essentially a matter of reason and common sense." And at page 239, they mention that, and we quote, "In law, therefore, when evidence is said to be irrelevant, it means either that as a matter of common sense, it is totally irrelevant, or that for the purpose of the trial, it is not sufficiently relevant to warrant it being received, because the practical disadvantages of receiving it outweighs its probative value," with close quotation, and we refer to the case of R versus Mpanza, 1915, decision of the then Appellate Division, 348 at 352, where the then Appellate Division held as follows, and we quote, "Any facts are relevant if from their existence inferences may be drawn as to the existence of the fact in issue." Some writers, my Lord, use the Latin terms facta probandum, which means that those are facts that need to be proved, or facts that are in dispute, and the term facta probanda, which means the facts that are used to prove the facts that are in dispute. In R versus Trupedo, 1920, also decision of the AD 58 at page 62, the court held as follows, and we quote, "The general rule is that all facts relevant to the issue in legal proceedings may be proved. Much of the law of evidence is concerned with exceptions to this general principle, but where its operation is not excluded, it must remain the fundamental test of admissibility." And, my Lord, we just want to emphasize the point that unless the operation of this general rule is excluded, it must remain the fundamental test of admissibility. In paragraph 9, we deal with section 210 of the Criminal Procedure Act 51 of 1977, which reads as follows: "No evidence as to any fact matter or thing shall be admissible, which is irrelevant or immaterial, and which cannot conduce to prove any point or fact at issue in criminal proceedings. Then we refer to a few cases, my lord. We refer to, in paragraph 10, to the case, well-known locus classicus of State versus Baleka and others, that supra must in fact be infra. We refer to the quotation later, there's Baleka 1, 2, and 3. We're referring to Baleka and others 3. Judge Van Dijk's, as he then was, stated as follows at page 1026, C to D, we quote, "It follows from what I have said above that I deal with tape recordings as I would deal with any other type of real evidence tendered where its admissibility is disputed. The test is whether it is relevant. It will be relevant if it has probative value. It will only have probative value if it is linked to the issues to be decided. That link will often have to be supplied by evidence of identification of voices on the tape where the identity of a speaker is an issue. This proof of relevancy need only be prima facie proof. Consequently, no trial within a trial should be held on the question of admissibility." And this was also followed, my lord, in the later case that we'll be referring to of Mutata, an officer of this court, Nkola John Mutata versus Desmond Ne, Regional Court or Senior Magistrate, the then Senior Magistrate of Pretoria, and the Director of Public Prosecutions. We give the quotation on paragraph 26. We will deal with that case in turn. Coming back to the point that we were making earlier on, in paragraph 11, we mentioned, my lord, that at issue in these proceedings is for the court to determine whether the prerequisites in section 217 of Act 51 of 1977 have been met. In other words, whether the state has acquitted itself of the onus to show that accused number 2 has made the statement as per Exhibit JJ, and if so, whether he did so freely and voluntarily. We submit, my lord, with respect that the recording is relevant as the court can listen to the recording in order to determine whether accused number 2 has firstly made the statement and secondly, whether he did so freely and voluntarily. Then under characterization of the recording, in paragraph 13, a pertinent question that must be asked is what is the nature or the type of this recording? We refer to the case of State versus M, 2002, volume 2, SACR 411, the SCA decision, where the following was stated at page 432C, and we quote, "Real evidence which is procured by illegal or improper means is generally more readily admitted than oral evidence so obtained, which depends upon the say-so of a witness." So, my lord, the SCA here was prepared to say that real evidence is to be preferred above oral evidence, even if such evidence is procured, as the SCA put it, in an illegal or improper manner. And we refer to a case that was quoted there, R versus Jekoi, the reference is given there. And the writing of the court was as follows: the reason being that it is usually possesses an objective reliability. So applying then the ratio in this case, the recording in question possesses objective reliability. The court went on to hold that it does not conscript the accused against himself in the manner of a confessional statement, and the court referred to the case of Holford, and went on to hold that the letter in this case can be classified as real evidence of a documentary nature. And we emphasize what the court said: real evidence is an object which, upon proper identification, becomes of itself evidence, such as a knife, a photograph, or voice recording, as in the current instance, the recording by Magistrate Cronje, as we've already submitted, constitute real evidence. And reference is then made to the Retters Schmidt on Bewijsrecht and Hoffman and Zeffert, South African Law of Evidence. Then in paragraph 14, in the matter of State versus Baleka 3, we give the quotation later on. The court held that, and we quote, "I deal with tape recordings as I would deal with any other type of real evidence tendered where its admissibility is disputed," and we close quotation. Paragraph 15, we refer to the case of S versus Mpumlo and others, 1986, volume 3, essay 485, where the then Judge Mullins had the following to say at page 490, H2I, that, and we quote, "A video film like a tape recording is real evidence as distinct from documentary evidence, and provided it is relevant, it may be produced as admissible evidence, subject, of course, to any dispute that may arise either as to its authenticity or the interpretation thereof," and we close quotation. Paragraph 16, we've already referred to this paragraph when we're dealing with paragraph 13. Paragraph 17, we therefore submit, my Lord, that the recording by Magistrate Cronje is real evidence. Then under D, we deal with the issues that must be proven by the state for admissibility of the recording. Paragraph 18, Magistrate Cronje testified that the recording was made on her work-issued laptop, but has been provided to the state on a memory stick, implying that the recording was copied from her laptop computer. And we mentioned, my Lord, that there's been considerable judicial debate concerning the prerequisite for admissibility of tape recordings, and as well as video recordings. We make the submission here that the recording by Magistrate Cronje is similar to tape recording in nature. And as the court mentioned yesterday, there are a number of cases emanating from the Natal Provincial Division, notably State versus Singh and another, 1975, volume 1, essay 3, as well as the case of State versus Ramkhobing and others, 1996, Volume 4, Essay 117. And as against these cases, a number of decisions in this division, and in particular, State versus Baleka and others, Volume 1, 1986, 4 Essay 192T, and S versus Baleka and others, Volume 3, 1986. I'm sorry, there's Baleka number 3. The first one was Baleka number 1. This is Baleka number 3, 1986, 4 Essay, page 1005, the decision of the then Transvaal Provincial Division, in which two cases, the decisions in Singh and Ramkhobing were expressly disapproved of, as well as the matter of Mpumlo and others that we have referred to. We refer to the case of State versus Nevote, 1990. We give the full quotation there, 1990, Volume 4, Essay 217. Decision of the then Appellate Division, where EFR Judge of Appeal pointed out that the difference in approach between these cases came down to the question of whether proof of the authenticity of a recording tendered in evidence was a prerequisite for admissibility. The Judge of Appeal mentioned that whereas in Singh and Ramkhobing cases, it was held that it was indeed a prerequisite, the contrary view was held, or the contrary was held in the Baleka cases on the ground that a distinction must be drawn between the originality of a recording and authenticity thereof. Wherein Judge Van Dijkhuis, as it then was, held that whereas originality affected admissibility, authenticity did not. And we, in paragraph 20, we again refer to the case of State versus Ramkhobing, where the then Judge President of the Natal Division, Milner JP, held that even though he was bound by the Singh and another decision, he expressed certain reservation at 134E about the correctness of that decision in this regard. In doing so, he referred at page 134J, 135B, to certain American decisions where copies had been admitted on the grounds that they were inter alia as faithful as the originals. He stated, however, that in these cases the original was either produced or its absence was explained to the satisfaction of the court, and the faithfulness of the copy was established by evidence other than the tape recording itself. My Lord, we have Exhibit TT that will establish the faithfulness of the recording. We also have the evidence of Magistrate Cronje, who will confirm the correctness of the copy. In paragraph 21, we refer again to the first Baleka case, wherein Judge Van Dijkhuis criticized the judges in S versus Singh and another saying that they had not differentiated between originality and authenticity. And he went on to hold at 195H that, and we quote, originality is a requirement flowing from the so-called best evidence rule and is considered when admissibility is decided upon. Authenticity is not a question of admissibility, but of cogency and weight. My learned friend, Advocate Mngomezulu, yesterday referred to the best evidence rule. And Judge Van Dijk, of course, expressly disapproved of the dictum in SS versus Singh, stating at page 199G that, in his view, such recordings were real evidence to which the rules of evidence relating to documents were not applicable. He stated further at page 199J to 200A that even if we were to be wrong in that approach, secondary evidence of the contents of originals was admissible in circumstances where the originals were on the probabilities and for all practical purposes unobtainable. And in this instance, my lord, Ms. Cronje can testify about the whereabouts of the original recording. And my lord, we must keep in mind that we're still busy with a trial within a trial. The state is still at liberty to lead evidence regarding the original recording. The court went on to hold that such secondary evidence could take the form of a copy, which is currently the position, my lord, in the form of a memory stick. Whether it was trustworthy was for the court to decide at the end of the case. And in the third Balika case, Judge Van Dijk reiterated that the views expressed by him in the earlier case, the first Balika case at 102.5b, that the requirements that the recordings be the originals flows from the equation of tapes with documents and the application of the best evidence rule to the former. And he says, I can find no ground or authority in our law for this approach. Then at page 125C, the learned judge states further that I can see no objection to the use of a copy, provided the court is satisfied that it accurately reflects what was recorded. And my lord, the submission of the state that Ms. Cronje will be able to authenticate the copy as accurately reflecting what is recorded. Paragraph 22 in S versus Ramosepele that we've already referred to, the then JP of the Natal Provincial Division, Judge Milner, held that a copy may be admitted in cases where the absence of the original is explained to the satisfaction of the court, and the faithfulness of the copy is established by evidence other than the recording itself. Paragraph 23. We make the point, my lord, that it must be borne in mind that the issue of originality of the recording, the best evidence rule, as Advocate Mngomezulu put it, and authenticity, he argued yesterday that the need for the recording to be examined by the expert have arisen in a trial within a trial. The state is still at liberty to lead further evidence thereon. paragraph 24, we mentioned that the accused has been afforded the protection of such evidence being led in the trial within a trial, and that should the recording be found to be admissible in evidence, the weight to be accorded thereto will still have to be determined by the court at the end of the case, bearing in mind too that a ruling on admissibility in a trial within a trial is interlocutory and may be reviewed at the end of the trial in light of later evidence. So, my Lord, should further evidence come to light, the court can always revisit the admissibility of the recording. We refer to the State versus Mngomezulu, 1966, Volume 1, SA 736, decision of the then Appellate Division, wherein the court held that should they, however, be declared inadmissible, then at the end of the trial, no prejudice would have been occasioned to the accused, as we dealing with a trial within a trial which is insulated from the main trial. And the court makes the when the defense made the point that the court would have then have had sight of such evidence. The court held that judicial officers are almost daily confronted with similar situations, such as, for instance, where a confession provisionally held to be admissible is later excluded from evidence, or where hearsay evidence provisionally admitted is later excluded. The court held that their training equips them to disabuse their minds of such inadmissible evidence. And we once again refer to the first Baleka case, where the court at 196F held as follows, and we quote, "To sort through contradictory and often false evidence and sort it from chaff is the daily task of the judicial officer. It is done in the case of viva voce evidence and can just as easily be done in the case of tape recordings." And in this case, in the case of recording by Magistrate Cronje, in paragraph 25, we mentioned that Magistrate Cronje is the authenticating witness and can testify about the authenticity of the recording and the accuracy thereof. And we refer to the case of State versus Nivot. The quotation will be given later, where in the court held as follows, and we quote, "Daarenteen is ek nie bereid om as submissie van meneer De Villiers op een stadium gemaak het te aanvaar nie, namelijk dat daar slechts gelet moet word op wat die deskundige getuies waarneming was. Om te hoor watter woorde in hierdie soort opname voorkom, verg geen deskundigheid nie, en 'n gerechtshof kan in geval nie sy funksie aan die getuies delegeer nie. Natuurlijk moet aggeslaan word op die getuienis, maar uiteindelik is dit die hof se taak om te bepaal wat die woorde is en deur wie hulle gebruik is. So in other words, my Lord, it remains this court's duty to make a finding on the recording, and we submit that the best ways for the court to listen to the recording which will also assist the court to determine the admissibility or the prerequisites, my lord, as mentioned in section 217. As stated by Judge of Appeal Yefer, where the authenticity of a tape recording is an issue, in a case where the state wishes to tender the tape recording as evidence, the crucial question is whether the state has excluded the reasonable possibility of a false recording, and whilst the version of the defense hasn't been put to Ms. Cronje, it hasn't been raised up to this point that the recording is false, and the court then referred to the English Head Note 220F, wherein the judge held as follows, and quote, "The question has to be answered with reference to the cumulative effect of all available indications without the state being expected to exclude every separate factor which might count in favor of the accused. Therefore, where it is alleged that there is a strange voice on the recording, which could imply that the recording is not being authentic, and the court is not able to determine from its own observations," and here, my lord, the emphasis falls from its own observations, and with the aid of an expert evidence whether a strange voice does occur on the recording, the court's aforementioned inability, together with all other relevant facts, should be considered as part of the totality of the evidence in order to determine whether the reasonable possibility of a false recording has been excluded. So in other words, my lord, the court has got to inform itself through its own observations as to the whether reliance can be placed on the contents of the recording, and we submitted the only way, my lord, is to by listening to the recording. In paragraph 26, we mentioned, and this is what was held in the Mutata matter, that authenticity encompasses authenticity of the recording, an issue which encompasses proof of reliability, veracity, originality, and accuracy. And as we've just mentioned, my lord, this is what the court held in the Mutata matter, and we give the quotation there at paragraph 35. In paragraph 27, we mentioned that in the Mutata matter, the testimony of the eyewitness was to the effect that the data files relating to the video clips taken by him were stored on a so-called SD memory card in the cell phone, and later the same day he downloaded the video clips to his personal laptop computer, thereby transferring the data from the SD memory card to the computer. Then, as fate was to have it, on the 20th of August 2007, prior to the commencement of the trial, his cell phone fell and was irreparably damaged. And further on, a digital camera with which he had taken certain photographs on the night in question was also stolen. And the relevant SD memory card was missing. And after the commencement of the trial, the 5 video files were copied from his laptop computer onto a memory stick and then onto a compact disc. A transcript of the contents of the 5 video clips was also made. In this instance, as far as the transcript is concerned, it has been requested. It's not yet available. So the facts in the Muntata matter are on all fours with what we currently have, my lord. In this instance, the distinguishing feature is the fact that the original recording is still being sought. Should the computer is available, I think the evidence of Magistrate Cronje was that the computer is available, and once it's located, the hard drive will then be mirror imaged, and then the original or a copy of the original of the hard drive will then be handed up in court. And there are various ways, my lord, of determining whether the mirror image is the exact copy of the hard drive. I think they use what they call a hash value, and the state will then lead evidence on that aspect. Then paragraph 28, we refer to the fact that the defense in the Mutata matter objected to the playing of the video clips in court, as well as the introduction into evidence of the transcript. The court held at paragraph 43 that, and we quote, "In all the circumstances, we are of the view that nothing has been put before us to show that any grave injustice or failure of justice is likely to ensue if the recordings are played in court in the course of a trial within the trial." And we submit, my lord, that also in this instance, there'll be no grave injustice or failure of justice if the recording is played.
Is that the SCA speaking there?
No, that is now this division.
Yeah. Who was the judge, by the way?
Two judges, yeah. 2 judges.
So who and who?
It was Judge Hanke and Pickering.
Of course, they were not from this division.
It might have been so.
Yes, because John.
Yes, because
my brother John,
yes.
that judge.
Yes.
Was
from this division.
Was from this division. So it would follow that
the source,
for fairness and
yes,
interest of justice, other judges from other divisions,
yes,
would have to handle the matter. So yes, it was Henke and
Pickering.
And Pickett.
Pickering,
yeah, from the Eastern Cape.
Yes.
And Henke was from the Orange Free State, ne?
It could be, my lord.
Okay, fine.
I'm not sure about that. Then finally, my lord, we then make the point, that court held then that in the Mutata matter that being the case, there are no grounds upon which this court may intervene at this stage of the proceedings in the court below. In the Mutata matter, the
application.
The parties applied for, or the applicant applied for the review of the proceedings of the lower court, and the court, as we've just mentioned, came to the conclusion that there was no reason to interfere in the proceedings of the lower court, and the application was dismissed. We respectfully submit that the state should be allowed to play the recording. This is as far as we can take our argument.
So is that the state's contention that the procurement or the making of the audio videotape by Mrs. Cronje was not in conflict with the law as espoused in the
Yes.
Act, is it Act 127 of?
Yes, the RICA Act, yes.
The RICA Act.
Yes.
Because the RICA Act, if I recall, says that a person like Mrs. Cronje, who was in effect monitoring and making the audio tape, need not apply for permission from a judge.
Yes, that was never the intention of the legislature, and I don't know whether one can put it as high as saying that she was monitoring the communication.
No.
Yes.
In a sense, she would be said to be monitoring because she was listening and taping.
We would submit that she was merely recording.
Recording, okay.
Yes, yeah.
Not for the purpose of committing a crime.
Yes, indeed, my lord, and that is what the RICA Act, what the legislator had had in mind with the RICA legislation.
And what is the state's view about the invasion, the alleged invasion of the privacy of accused number 2, is it? When you make the tape recording, is his constitutional right in terms of Section 14 of the Constitution infringed in that his privacy has been invaded by such taping?
Well, my lord, would submit that in this instance, the recording is the electronic version of what the accused was telling the magistrate. So we submit that there's no room to argue that his privacy was infringed. He was in front of a magistrate making a statement in terms of Section 217, and all that the magistrate did, my lord, was just to keep a record. To keep a record of those proceedings. I'm not sure if one can argue that his privacy has been infringed, as it was just a recorder or a recording of Exhibit JJ. What the accused was, out of his own volition, telling the magistrate of his knowledge of the allegations that were being leveled against him.
Is the state's contention that let me ask this: what was the primary evidence? Because
the primary evidence, as we indicated, my lord, is the work-issued laptop that Mrs. Cronje recorded the proceedings on. And as indicated, my lord, I think Ms. Cronje did testify that that laptop is still available. Yes. So the state is still at liberty to, and that's what the state is going to do, to trace the laptop and then have a mirror image made of that laptop.
Yeah, having regards that this is evidence which is still being contested at this stage in a trial within a trial, which we all know that the findings thereof and the evidence subsequently thereof, unless there is agreement between the parties, has to be compartmentalized.
Yes.
On its own. Only maybe you could argue that the finding by this court to the contrary I don't want to presume to the contrary, may come to a point where that evidence is not related further in the trial itself,
Yes,
because
yes.
these are two exigencies.
Yes.
Mr. Mngomezulu says there is need for an expert. We heard him yesterday
Yes.
when I said,
Yes.
but-
He mentioned that.
yeah. At this stage, is it possible to appoint an expert
But
if the exigency arises or the need arises?
my lord, we submit that there's no need, as we mentioned, that all that needs to happen is that the hard drive is retrieved from the laptop, a mirror image is then made, and is then made available to court. We don't need an expert.
And at this stage, as I understand it, all the parties listened to the, except the court,
Yes.
listened to the audio recording of that tape. Is that not so?
Yes, indeed. Over a period of 2 days, the accused have also been afforded the opportunity.
They also
to-
listened.
Yes. Yes.
So consequently, if there is a foreign voice in that tape, the defense still has a chance to attack the authenticity of that voice, which they allege is
Yes.
perhaps foreign.
Indeed, my lord, and they can put their version to Mrs. Cronje to comment, and all the parties, including the court, will then have the benefit of watching the recording and then
Yeah.
making own observations regarding that aspect.
So is that your final submission,
Yes.
that this court cannot rule on this application without listening to the tape?
Indeed, my lord.
I suggested that yesterday and I was told cuckoo.
Yes. Well, we think, my lord, that is the best way of dealing the issues, and we don't want to preempt what the defense
Yes.
version is going to be, but it will be prudent, my lord, at this stage that the recording be listened to, and it will put any doubt regarding as to what transpired on the day in question out of the way.
Thank you. Yes, Mr. Mngomezulu.
As it pleases the court, my lord. My lord, without wasting the court's time, I would like to make the following submissions. I'll address the court from the dock. I did not prepare the heads of argument. From the bar, sorry, from the bar.
Yes, no problem.
My lord, this court is seized with an inquiry to make as to the admissibility of, firstly, of a statement that is alleged to have been made by accused number 2, which the defense is objecting to it and has raised the reasons for its objections, among other things, duress, which is coupled with non-compliance with free and voluntary, and it was not made in his sound and sober senses.
Okay, I'm sorry to
In
interfere.
addition-
Sorry. I'm sorry to interfere. In your view, can this court, because the court is presently, as you say, involved in an inquiry regarding the issue whether the statement or the impugned statement or confession is alleged by the defense not to have been made freely and voluntarily, etc., right?
That's correct.
Now, this court, can it arrive at a decision concerning the inquiry which it is conducting without viewing, objectively viewing the auto video tape? I know your submission is that this court shouldn't view it.
That's correct.
But
that's the reason.
But then I'm asking whether this court can make a decision regarding evidence which is allegedly encompassed in that auto video without this court having viewed it.
It is indeed so, my lord.
Okay.
The reason why I'm making these submissions, my lord,
okay.
I just want to draw, or I'll submit that the duty and the power that has been imposed on the witness, the magistrate, in terms of section 2171B, Roman figure 2, was to make a confession, was to take a confession from the deponent or declarant, which was to be reduced in writing after all the prerequisites are met.
Yes.
Which include, one among other things, free and voluntary, sound in sober senses, without being influenced or induced to make such a confession. That is primarily what the criminal procedure is providing. This is the duty imposed upon the witness to do it. There is no extension of further work to be done by the witness in order to qualify the requirement in terms of that provision.
Even if he says he has taken an audio recording of the very pro forma questions and answers, this court must ignore that and say
that's my submission.
The only evidence the court should have access to is the written portion of the pro forma, as you say, as stipulated by 217 of the Criminal Procedure Act.
That's correct. That's my submission. I stand by that submission.
All right.
The reason being, my lord, is that prior to the invoking of Section 217, there are rights that needs to be explained to the declarant. One, among other things, the right to remain silent, the right to be informed promptly of his legal representative, the right to be informed promptly or to be presumed particularly of innocence until proven guilty. Such rights, after she has satisfied that she has explained such rights to the deponent, she can then comply with the prerequisites that are contemplated in Criminal Procedure Act, Section 2171B, Roman figure 2. In relation to the taking of the audio recordings, such rights were not explained to the declarant.
Yes.
It was taken by surprise by the state to say the witness went to the extent of violating the rights enshrined under Section 35 of the Constitution. How do you cure the right that has been infringed by this witness that is currently testifying? Firstly, one must look at the law of general application that is applicable to limit the right of that particular declarant. At present moment, the state has not advanced any available law of general application except to quote a provision which has not been enacted with the given powers that were given to the presiding officer or the judicial officer who took the confession. In this case, no rights are explained. Indeed so, my Lord, even if we are still contesting the fact that it has been taken freely and voluntarily, but we still maintain that a right has been infringed.
No, fine, I hear you.
Yes.
But you see, we're dealing with technology. When you say no rights were explained, that recording says it recorded, according to Mrs. Cronje, it records the conversation she had with accused number 2. It records that I'm warning you. Do you still want to make a statement even after I've advised you that this and this and this and this? It records that.
My Lord,
wait. There is no new information which Ms. Cronje says recorded, unless you want to submit that because of authenticity. It's possible that he recorded other things.
I'll get to that, my Lord.
Okay.
I'm still busy with the rights of the accused.
Right.
The issue of originality and authenticity, this is what I'm going to argue on in relation to what has been submitted by the state.
Okay.
But the point of contention at the moment, currently, is that a situation where a right has been recorded is a different situation where a right has been explained to the declarant to the effect that you must know that I am going to take your confession in writing, but you must know further that I'm going to record what you are going to say. That's our point of contention.
Fine. I hear you.
Yes. Hence, my submission in relation to the right is that it has been infringed. There's no way that such right, after it has been infringed, it can be cured.
Okay.
Furthermore, we look at the provisions of Section 35(5).
Yes.
The legal question here would be, was the recording per se obtained in a rightful way? What does Section 35 say? May I read it, Josh?
I know it.
For record purposes.
Oh, I see.
Yes. It provides that evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair. How was it obtained? It was only the person who took it that she knew that she was taking evidence without the knowledge of the declarant. So, in essence, such evidence, it is my submission that it should be excluded.
Yes.
These tape recordings should be excluded in the circumstances that they will definitely violate the rights that are enshrined in the Bill of Rights or the administration of justice. That will be supported by a case law in Gumeta versus the state and state versus Magwaza. I'll give the full citations, where in both cases the courts came to a conclusion that such evidence that has been obtained where a right has been infringed were excluded. Okay. My Lord,
yes.
In conclusion on the fact of Section 2.1 7, 1B, Roman figure 2. I'll make submissions in relation to what was submitted in the case of Nkola Mtata versus Dinaya and the Director of Public Prosecutions. One of the submissions that the counsel for the applicant submitted was also relied on the listening of the recordings, where he submitted counsel Advocate Dokota. He mentioned that the presiding officer or the presiding officer made a mistake by allowing the recordings to be heard. Hence, the matter had to be postponed for review. But the subject matter on the application was the interference of the higher court in respect of the matter that has not been completed in the lower court. Hence, there were some other reasons for the dismissal of that application.
But the long and the short of it, 2 judges said it can happen.
Yes.
In other words,
it overrided the decision of Wallhouse. Wallhouse, there's a case that I've read of Wallhouse, and they overridden that decision.
Is that Wallhausen, the jet?
That's correct.
I know, that's the Burramach story.
That's correct.
Yeah, I know that.
So in my submission is that contention that was submitted by Advocate Dokota then was a genuine submission to the effect that if the reasoning behind what Dokota was saying is that whatever was in the mind of the presiding officer who saw or listened to the videotape cannot be deleted in his mind during the trial, because that piece of information or evidence that has been led in his presence will definitely be detrimental to the administration of justice.
Your brother here says judges are trained to disabuse themselves of inadmissible evidence. Your brother.
My Lord, may I reserve my comment?
Well, he quotes the law. You see, he doesn't just say it. He's quoting Decust. You don't have to stand up. Yeah, he's quoting Decust. Okay, you can go on.
Thank you, my Lord. My Lord, that evidence, before one looks at how it was obtained, what are the prospects? We look at the case of Nkola Mutata as the dangers that may be, that may produce upset results, such as the manipulation of the material. The original documents were lost, and there were copies that were made, and they submitted the copies. It's straight law that original documents should be presented unless the parties, if they accept or agree on the presentation of a copy and agree on the contents of what is contained in that particular copy. In this case, there is a major dispute or an issue relating to the admissibility of such a document. During the examination of the witness, and when I perused the pro forma of the witness, there are certain things that came to my mind, which I may reserve it if the court so wish me to reserve them.
Now you're still going to cross-examine. I don't have to hear that.
Subject to cross-examination, of course, my Lord.
Yeah, I know.
But I would submit that all that I will say is that the state, after seeing, it's my submission, they can rebut the submission if they wish to do so. The state, by bringing an ambush disclosure, so that there might be patent and latent defects on the pro forma.
Well, how would you argue that, sir?
I'll be.
No, but listen to what you're saying. You're saying the state, in realizing that there are lacunas in the evidence of Mrs. Cronje.
Correct.
They want to rectify that by bringing the evidence of a tape.
Of the tape.
Yeah.
That's correct, my lord, because I was opportune to see or to hear or to listen to the recordings. Hence, this submission is made with the premise that at the end of it, I see now the reason why there is an ambush.
Okay, I hear you. And
Thank you.
Basically, by logic of extension,
That's correct.
you are saying, should this court, are you arguing that this court should not see or hear, should not?
Should not.
This court should not.
Not at all. Not that I say
Okay.
the court should not hear at all. The court should actually ventilate the issue first of what it has been provided with. That's my submission. On the pro forma, because if the state is adamant and vividly sure that there is no supplementary information or to be supplemented on the pro forma, surely there would be no need for the state to use the recordings.
All right, let me remind you what I said when all of you told me that that portion must be redacted. That portion must be redacted. And I said, when you say it must be redacted, are you saying I mustn't see it? And the unanimous answer was yes. You know the decision, I've got them here. That the viewing and the listening of the tape recording, because it's secondary evidence, it's tendered as secondary evidence, which is the same almost as the contents of the pro forma question and answer from 1 to 13, which form what you would say is the primary evidence.
My lord.
So, wait. So the reduction, the state and the defense agreed that certain evidential or probative allegations this court mustn't see. And it was an agreement between you and the state. So the reduction, what should I do about that, of the pro forma?
Of the pro forma, my lord, we cannot change the position as it is, but we cannot further the illegalities that may occur in future by allowing this kind of evidence to be tendered.
Yeah, okay, fine.
My lord, in relation to the aspect of the authenticity of the document,
Yes.
as opposed to the originality of the document, it is
the tape.
the tape. Oh, yes, thank you, my lord, for correction of the tape. On the aspect as it has been contended or held in Balega's case, that the originality defeats the admissibility of that particular evidence. But the authenticity does not, because it has its own effect. The state has made submission that it does not have the original material that it intends to use.
No, that's not how I understood your learned colleague.
I mean,
He says the computer is available. What was manufactured out of that the computer was the stick, the memory stick. He says the original, in other words, the original recording is encased in the computer. What was delegated to the stick, it's not the original. And they say they're prepared to make, am I correct, sir? They're prepared to make that computer available to the defense.
my lord, be as it may,
Okay.
be as it may, the fact that the originality of the material, if
In other words, Mr. Baloyi says the originality is immutable. In
That's
other
correct.
words, it exists as we're speaking to you.
That's correct.
It's not like a document in the case of my brother Motata, which was lost. The computer was lost, etc., etc., etc. And that evidence had to be reconstituted, and it could never be original.
that's correct.
Okay, right.
The principle of best evidence must also apply.
Yes.
It must apply.
You're right, sir.
And the evidence of an expert, because at the stage when such a production was made or intended to be made, there was no agreement between the parties after listening to the tape that the person, the speaker, is the one that is alleged to have made a written confession. If the court was to be invited to listen to the tape,
Why don't you want to invite the court?
the court will come to a fair conclusion, because there's already an evidence before this honorable court.
Yeah.
In the event, my lord, there was no tape recording, the implication cannot be said. The court would have a difficulty in finding in favor of admitting that evidence. It would still make a difference. It would still
Yes,
make a
I hear
conclusion.
you. I hear you.
Hence, it is my submission, and my colleagues, I think, they will submit further in relation to
Okay, no, fine.
court places.
Okay, no, I just want you to address me on this. This is old law, 1952-3. This was a case involving a magistrate in the lower court, and it related to the transcript of a dictaphone and telephone wire recordings. It went on appeal. But this is what the magistrate allegedly is said to have done. Himstra, who was acting for the appellant, submitted that the contents of the dictaphone records could be admitted. He submitted that the magistrate should himself have listened in court to the records being played, even if he had to do so with earphones, and even if no other person would have been able to hear the recording. If the records could be played so as to be reasonably audible to the appellant, his counsel and the magistrate are at one, rendering that it should, in my opinion, have been done unless the defense agreed for the transcript to be. Anyway, from Jan van Riebeck's time, they say the court must listen. Further, he says, in the case of a photograph, the court itself looks at it, whereas the court did not itself hear the recording. If the recording could be done so as to be audible to the court and the parties there, it is, in my opinion, there's no reason why the judicial officer should not himself listen to the recording instead of being told by some other person what he has heard. If that were done, there can, in my opinion, be no doubt that a witness could be permitted to testify whether any of the voices recorded were, in his opinion, that of any particular person with whom he interacted. So you say I shouldn't listen?
My Lord, I still stand by my submission.
Yeah, fine.
I'm happy that the Honourable Court is quoting the matter where there were no rights at that time.
More truth today because there are rights.
Today we are protected by rights,
Yeah.
and such rights are violated. So,
It's the other way around. There were no rights then. It was the discretion of the judicial officer.
That's
Today,
correct.
the judicial officer is bound by the Constitution.
By the Constitution.
Right, okay, you can
In
go
this
on.
case, that's the reason why we rise to submit
Okay.
that the rights of the accused are likely to be infringed or
Okay.
further infringed
All right.
in the event. I'm not sure. My Lord, I've addressed the court.
No. You're at
I
liberty
think,
to...
is there anything that maybe the court wants me
Now,
to
let's hear your
address?
colleagues first. If at the moment you're saying, Tata Ikefu,
Yes.
let's hear the others. And then we can come and revisit some of the questions I want to put to even to your learned colleague and all of you.
Court please.
Yes, Mr. Mnisi. What's the time now? Let's just check the time. Oh, okay. Let's continue then.
Is it please the court, my lord?
Yes.
My lord, I won't be long. I'm going to be very short, and I will try not to conflate issues.
Okay.
The situation is very succinct, my lord. We're not saying that the court should actually not listen to the recording by Mrs. Cronje. However, what we are putting before court, my lord, is the fact that in a situation where the admissibility of electronic evidence is at issue, then the court must hold a trial within a trial to determine the admissibility of such piece of evidence. That is just a precursor, my lord. It will then, only after the court has made a ruling that such evidence gets to be admissible, then the court will then go on and listen to such recording, my lord.
Yeah, but you're correct, Mr. Mnisi.
Yes.
But the fact of the matter is, you see, we started with accused number 1 when he contested the admissibility of the alleged confession.
Yes, my lord.
Before Mboto. And the court, because as you know, the accused are charged with conspiring in the pursuance of a common purpose.
Yes, my lord.
So maybe it will be tautologous if I say I obviously did make a ruling that a trial within a trial must be held. Now that we are dealing with the interception of communications in terms of the act,
Yes, my lord.
we must hold another trial within a trial. We are holding a trial within a trial. It's a continuous exercise, okay?
That is the procedure, my lord. I think the court has already been referred to the
Yeah, quite.
Mutata case.
Yes.
Just a very brief about what happened at Mutata
Yes,
case. The court that was hearing the matter at the regional court in Joburg had a trial within a trial to decide on the admissibility of the evidence that was contested then, which was the recording from the cell phone and all those gadgets. Judge Mutata, and then the final ruling of that court was to the effect that there's nothing wrong in the court listening to that audio hearing. That is after a trial within a trial was then held. Judge Mutata was not happy with that decision, and then he took it on appeal. On appeal, unfortunately, things did not go his way. That is basically what we're saying here, that there should be a precursor. There should be a precursor to a hearing of this audio by the court.
What is the precursor? What is the precursor, according to you?
In other words, we should not put the cart before the horses.
And
the horses should always be in front.
What are the horses? Using that example, the cart before the horses. That is the precursor you're talking about.
What I'm saying, my lord, the precursor to what is happening now is for the court to have a trial within a trial to decide on the admissibility.
We're having that.
And, that is very different, my lord. We are having a trial within a trial to decide on the admissibility of the confession, the pointing out, and the other document as well, but not specifically with regard to now the new information or evidence that is now contained.
So we must have two trials within a trial.
That is what the process is supposed to be, my lord.
I told you it's tautologous. Because we are addressing all the exigencies of the trial within the trial. The pointing outs, the alleged confessions, everything.
It is unfortunate, my lord, that as we are holding this trial within a trial, another aspect comes out which would necessitate a trial within a trial to decide that very aspect that has come out in the process of a trial within a trial.
Yeah, fine, I hear you.
Which is the audio. And the reason, simply because, my lord, I'm saying that the court needs to hold a trial within a trial to decide the admissibility of this audio recording, mentioned in the Electronic and Communications and Transaction Act 2002. I think they are there in Section 15 of the Act, which says as follows, or aptly says as follows.
Okay, I hear you.
Yes.
Okay, maybe because you were not here at the beginning of the arguments.
Yes, my lord.
I am at the moment holding a trial within a trial regarding the admissibility of the audio recording which was made by Mrs. Cronje, to the effect that is it admissible in evidence or is it not? That's it. We want that.
The process of holding a trial within a trial, my lord, is to call witnesses, is to put the grounds on why that evidence is contested.
I know.
I'm not so sure whether that happened, my lord. I'm not so sure whether there's a witness who has already testified with regard to the authenticity, the originality, the storage and everything of that audio.
At the moment,
yes, my lord.
As I view it,
yes, my lord.
It's interconnected, but in essence, this court now, in terms of Section 145C of the Criminal Procedure Act,
yes, my lord,
it's deciding a matter of law.
Yes.
Whether, as a matter of law, those audio recording made by Mrs. Cronje is admissible in evidence. Now, that is the precursor. If I find that it is admissible, that's not the end of the story.
Yes, my lord.
You see?
Yeah.
Then the onus is on the state to proceed and prove whether, in fact, the other aspects, they've proven them.
I'm well aware, my lord, that at the end of it all, the fact that the court has ruled that the audio recording is admissible
or not,
it's not, let me say, if the court rules that it is admissible, that is not the end of the story.
Yeah,
I think that aspect has been touched upon by my colleague. Yes.
It's not evidence which determines whether this court is holding a trial within a trial. Are you with me?
I did not get that, my lord.
The decisiveness of this court finding that the evidence regarding the tape recording is admissible, right?
Yes, my lord.
The trial within a trial is still continuing because that evidence came out during the evidence of Mrs. Cronje,
Yes,
who
ma'am.
was testifying in a trial within a trial pursuant to Section 217.
From where I'm standing,
Yeah.
my lord, I think these are two processes that
Yes, they are, you're right.
that are not the same.
Okay, fine.
Because the
Okay.
first trial within a trial has got to do with
The statement.
the admissibility of the statement
Right.
that were allegedly made by the accused.
Right.
And what I'm submitting now is within that trial, within a trial, in other words, within that first trial within a trial, something came up
Yes.
which then necessitates
Yes.
a trial within a trial in the context of the first trial within a trial, which is the admissibility of the recordings.
Okay, fine. I can declare that we are also conducting a trial within a trial regarding the admissibility of the audio recordings. Does that cure your problem?
If what is happening now, my lord,
Yeah.
then it's a trial within a trial, then I'm not in a position to take the matter any further.
It's
Because
interconnected. That's why I was saying you're not holding a trial within a trial in respect of one aspect. We are even holding a trial within a trial of the pointing outs, which your learned colleague will probably have to lead evidence on after this issue regarding whether the audio recordings are admissible or not.
Yes, my lord. As I'm saying,
Yeah. No, you're correct.
If what is happening now is a trial within a trial, then I'm not in a position to take the issue
Yeah,
any
because
further,
I can't
that was actually my point.
Okay, fine. I agree. That's why Mr. Mngomezulu
Yes.
talks about rights which have been infringed by Ms. Cronje,
Yes.
and that she did not alert his client about the fact that she is recording
Yes,
the
ma'am.
pro forma
Yes.
questions and answers.
Yes.
And consequently, he says those rights in Section 35(5),
Yes.
namely of unlawfully acquired evidence, which is to be excluded, and evidence which, if it is admitted, it will bring the administration of justice into disrepute. Am I quoting you correctly, sir?
That's correct.
Yeah. So it's intertwined. Yeah, but you're correct.
Then I may not take this point any further, madam.
Okay, fine.
I will rest my case.
Okay.
Thank you.
Mr. Khumalo.
My lord, I was going to follow the same approach of my colleague, that at this stage we're dealing with the trial within a trial in terms of Section 217 of the CPA.
Yes, you're right.
So we don't have a problem if the court were to listen to the video recording, but it must hold a trial within a trial. I think the court has ventilated that we are in the process of conducting a trial within a trial, so all the issues are going to be ventilated in the trial within a trial.
No.
But I wish...
Let's be tautologous. We are holding a trial within a trial whether the statement allegedly made by accused number 2 has been made freely and voluntarily without being coerced.
Yes.
Right?
Yes.
And during that, the viewer of the deponent, accused number 2, gives evidence regarding the questions and answers she asked of number 2.
Yes.
And then it transpires that
There's a video.
there's a recording, audio recording.
Audio, yes.
Right?
Audio recording, yes.
And now you guys are contesting the admissibility of that.
Yes.
Right?
Yes.
That's why I say it's intertwined with the trial within a trial which we are
Yes.
holding for accused number
Yes.
2,
Yes.
whether the statement or confession he made is admissible or not. It incorporates even the statement, the audio
Yes.
recording which was made by Mrs. Cronje,
Yes.
because that audio
Yes.
is made during the course and scope of Mrs. Cronje interviewing
Yes.
accused number 2.
Yes.
And it extrapolates to whether now that audio video recording, is it admissible
Yes.
as evidence?
Yes. Yes. So we can incorporate the whole thing.
I don't. The facts incorporate that, not
Yes.
me.
As long as there is going to be a trial within a trial as well to ventilate the issue of the audio recording. But I tend to disagree with my learned colleague for the state, my lord, that the RECA Act is applicable.
Is that so? Okay.
Yes. The act that is applicable in the whole process, it is the
127.
Electronic Communications and Transactions
number?
Act. It's Act number 25 of 2002.
Yes.
The relevant provision
Yeah.
is section 15, subsection 3 of the Act.
Okay.
So it governs this whole procedure.
Okay.
Yes, thank you.
You'll respond to that, I'm sure.
Yes, he will
Okay,
respond. I'm
thanks.
sure. Yes, thanks. Thank you.
Yeah. Yes, Mr. Mchololo.
Thank you, my lord. My lord, firstly, I would like to respond to paragraph 11 of the submissions made by the state in the heads of arguments,
okay.
my lord. Yes. Which says, my lord, it's paragraph 11.
Yeah, okay.
Yes. It says, at issue in these proceedings will be for the court to determine whether the prerequisites of Section 217 of Act 51 of 1977 have been met, whether the state has acquitted itself of the honors to show that accused number 2 has made a statement as per Exhibit JJ, and if so, whether he did so freely and voluntarily. My response, my lord, to that, and I would like to draw this court to the attention of the case of S versus Magwaza. My lord, I'm reading it from the
Yeah, I've got the case of Magwaza here.
Yes, Magwaza.
Yeah.
2016, volume 1, SACR 53 in bracket SCA.
Okay.
Where the trial court and the full court focused solely on the voluntariness of the pointing out and confessions. Both were criticized for not touching even tangentially on the Constitution's exclusionary provisions, Section 35(5), my lord, applicable in this case. Where there was certain reason to do so, the right of an accused to be informed of his rights and the consequences of an infringement of this right.
Yes.
My submission, my lord, is that we are in a trial within a trial in respect of Exhibit JJ.
Yes.
And the content of the statement has been blocked before this court. Yes. That content has not been revealed yet.
Yes.
And we have agreed to block in the incriminating statements or words in the document which has been submitted before this court.
Right.
Until the ruling whether the statement is ruled admissible or not by this honorable court.
Yeah.
My submissions, my lord, is that the witness, which is Ms. Cronje, as a magistrate, my lord, when she was taking down exhibit recording in terms of Section 217, he recorded the statement in terms of Section 217, subsection 1B. But the case law, which is ACA that I've just referred this court to, says the requirement of Section 217 only is not sufficient.
No, of course not.
Yes, my lord.
The Constitution, the whole Constitution is applicable.
Yes, my lord. And then in this case, my lord, I submit, my lord, that above meeting the requirements, if they were met, of Section 217, the magistrate who is the witness ought to have explained the constitutional rights of the accused specific to the recording, to say that above what I will be recording, what I will be taking down in the statement, in the document, I will also be recording, and the voice recording will be used in court against you.
Yeah.
Those constitutional rights, my lord, I submit that they ought to have been explained to the accused or to the deponent at that time before he made or before the witness proceeded with the recording. My submission, my Lord, is that as we are in a trial within a trial, until such a ruling has been made by this court, the video recording, which was unconstitutionally obtained in terms of Section 35(5), should not be played to the court because it contains incriminating evidence. My Lord, why I'm making that submission is because I have also listened to the recording. I have read the document that is in front of the court, which is Exhibit JJ. The state has also indicated, my Lord, will recall yesterday to say that they have realized that in the recording there is an additional information which is not contained in Exhibit JJ, and submitting the relevancy of leading the video recording. Hence, my Lord, I'm submitting to say the information or the evidence contained in the video recording is not the same as the document submitted before this court referred to as Exhibit JJ. If you listen to it, my Lord. As a result of that, my Lord, I will ask that we continue in a trial within a trial regarding the admissibility of the video recording first, and then after the ruling, the court then may listen to the video recording. Those are my submissions, my Lord.
Okay.
Yes, my Lord.
Yes.
Thank you, my Lord.
So you don't want me to listen to the audio?
Not per se, my Lord, that we don't want, but we want the court to, the admissibility to be dealt with first.
Yes, you're correct.
Yes, the manner under which this video recording was taken.
Yes.
Yes, so that for the court to determine on the admissibility. After the ruling, then it can be
listen
played.
to it.
Thank you.
If I rule that way, anyway.
Thank you, my Lord.
Okay. Yes. Yes, Mr. Baloyi.
Can I just respond to one aspect that was raised by
Mr. Mngomezulu.
Mr. Mngomezulu and Advocate Nishololo, namely the lack of explanation of the rights. They seem to suggest that, and we're not conceding to that aspect. You know, they say if there's a violation of the rights in terms of the Constitution, the evidence should automatically be excluded. That is not the legal position, my Lord. There is that case of
Is that
Key versus Attorney General. Yes,
okay.
Where in the Constitutional Court, per Judge Ekurhuleni, at paragraph 13, held the following. In any democratic criminal justice system, there is a tension between, on the one hand, the public interest in bringing criminals to book, and on the other, the equally great public interest in ensuring that justice is manifestly done to all, even those suspected of conduct which would put them beyond the pale. To be sure, a prominent feature of that tension is the universal and unceasing endeavor by international human rights bodies, enlightened legislatures and courts to prevent or curtail excessive zeal by state agencies in the prevention, investigation, or prosecution of crime, but none of that means sympathy for crime and its perpetrators, nor does it mean a predilection for technical niceties and ingenious legal stratagems. And this is what we want to emphasize. What the Constitution demands is that the accused be given a fair trial, and ultimately, as it was held in Ferreira versus Levin, fairness is an issue which has to be decided upon the facts of each case, and the trial judge is the person best placed to take the decision. At times, fairness might require that evidence unconstitutionally obtained be excluded. This is what they are arguing, but they did not mention the other side of the coin, where in the court said, but there will also be times when fairness will require that evidence, albeit obtained unconstitutionally, nevertheless be admitted. And there is the contention that we're making, that there's also the other side of the coin. Thank you.
Mr. Mngomezulu, any response to the Ekurhuleni judgment? It's a 1996 judgment, eh?
Yes, my lord, it's 1996.
Yeah.
17 May 1996.
That's it.
I stand by my submissions.
Yeah, well, the essence of that judgment is that although it sounds incongruous, because the general constitutional position is this, that like you quoted Section 35(5), evidence which is acquired unlawfully should be excluded and be made inadmissible. But Ekurhuleni says there are instances where the dictates of fairness demand or dictate that evidence which is unconstitutionally acquired should be made admissible in the interests of justice and in the administration, in the interest of the administration.
My lord, does that judgment of Ekurhuleni,
Yeah.
it came in 1996. I think the decision of Magwaza, it came after Ekurhuleni.
That's the Constitutional Court. That's Ekurhuleni in the Constitutional Court. Magwaza is SCA.
But basically,
Okay, fine.
basically, my lord, a right cannot be superseded by an element of fairness.
No, fine. I've heard you. I just wanted you to respond.
Yes.
Because you never, yeah.
Court.
Hobo, Mr. Minister, Mambili. Are you responding also to the Ekurhuleni statement? Right, you. That's even.
No, my lord. I think my line of argument is
yeah,
not
okay,
in
fine.
line what has just been proposed.
Okay, Mr. Khumalo.
My lord, my line of argument is totally away from the provisions of Section
Okay.
35. Yeah, thank you. So I have no response.
Mr. Chololo.
My lord, my submission is that the fairness cannot overweigh the constitutional right of the accused.
Okay, fine.
Constitutional right of the accused has been violated, madam.
Okay.
Thank you.
All right, is that it? So this court must now retire in order to consider whether the state has succeeded in persuading it whether the rights, whether the audio tape recording is admissible, and consequently also whether, even if the rights of, if the rights of accused number 2 have been infringed, I should rule against the admission into evidence of that tape. Is that not what I should decide? Okay.
Inkantolo manje sofanele ukuthi iyothatha isinqumo ngoba ke izethulo ezenziwayo lana zenziwa ke kuyinhlangothi ezimbili. Umshushisi ngolunye uhlangothi ucela ke ukuthi le recording, ngoba siyazi ukuthi udaba manje i recording ukuthi ke kufanele ukuthi ke yamukeleke na njengobufakazi noma ibe ingxenye yobufakazi. Kolunye uhlangothi ke abameli bona bathi cha, lokho akufanele, bathi futhi nenkantolo kufanele nje ingayilalelike noma ingayibukike manje leyo recording. So umehluleli uthi ke manje kufanele ke ahamba uyothatha isinqumo emuva kokuthi ke sekwenziwe izithulo futhi belethe ngaphambili ke amacala amaningi ke afanele inkantolo iwabheke, nanjengomzekelo ukuthi ke ahambisana nesinqumo sokuthi ibheke, abanye nesinqumo sokuthi cha ingayibheki. Inkantolo ithi ke manje kufanele uyothatha noma uyakwenza leso sinqumo leso.
Yeah, more especially that the facts in this case It's the first time they are ventilated in a court, in the High Court. Am I right, Mr. Mngomezulu?
That's correct.
I've read all the cases, all of them, starting from the 20s. It has never been a visitation of a court regarding the making of a recording of the pro forma question and answers encapsulated in terms of Section 217. Am I correct? Maybe you've read more cases than me. Yeah, as consequently, I've got to really consider this decision carefully. Okay, so the court will adjourn. When should we reconvene? Because we don't have any other witness now.
Yeah, Ms. Cronje is here, the interpreter, but we can
No,
make
she can't be cross-examined before.
alternative arrangements.
Yeah.
Yes, yeah.
You'll have to make arrangements. Friday, you were intending to do what?
That is tomorrow.
Yeah, you were intending to do what?
Yeah, well, we foresaw that
You saw
the
that
cross-examination might overlap to
a Kets
Friday.
Constable judgment.
I'm sorry?
That a like Kets Constable.
No. What we envisage is the two witnesses are waiting in the wings in case judgment is given.
What is that? Waiting in the wings?
They are just ready in case judgment is handed down. You know. So if the court needs to consider judgment,
Yes,
there's
I
no
have to.
problem a lot. The witnesses will be excused until such time as we can reconvene.
Yeah, tomorrow. I've listened to all the arguments. Okay, tomorrow then at 10 o'clock, the judgment will be delivered.